7, 6, 5, 4, 3, 2, 1.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, everyone. Hello and welcome to Restore Freedom Weekly. This is Season 2, Episode 14. I'm Constitutional Attorney Catherine Henry, and this is Liberty Lori. And today we have a very important topic to discuss with you. And I do believe we're going to be bringing in a special guest shortly. There is another important person joining us, at least in the chat on YouTube. That is Mr. Henry, Mr. Catherine Henry, as many people joke around with him about. Anyway, thanks for joining us today, everyone. And we're going to go ahead and get started. And I'll just wait for, or I'll lean on Lori to let me know when our special guest has come in backstage if I don't happen to notice myself. Hello to the
About 15 minutes.
15 minutes. Okay, good. Hello to the Liberty Cause and to all the rest of you joining us today on our various 9 of you. All right. Thank you to Lightning Dave on YouTube, who's apparently hanging out with 9 freedom fighters joining us today. So that's awesome. All right. So today's topic would be the 5 most common pretrial motions. And hello to Susan on YouTube. Let's see, bear with me here because I'm trying this a new way than I usually do it. So our technology now allows us to download, upload, blah, blah, all kinds of fun, different stuff here. So we're trying it a different way. All right. And hello to the rest of you that are continuing to join us on YouTube, Facebook, LinkedIn, Twitter, and Rumble. All right. So the 5, wow, why does that look weird? Okay, I'm not sure what's going on there, but anyway, that's not what it looks like on my end. Anyway, the 5 most common pretrial motions is what we're going to talk about today. And why? Well, are you representing yourself in court? Maybe you have an attorney, but you just don't have a lot of faith in your attorney. Hopefully, we're not going to get on one of those bar attorney discussions today, but at any rate, you still might not have faith in your attorney. I don't have faith in most attorneys, and I am an attorney, and I've been an attorney for many years in several jurisdictions. Most attorneys suck. All right, so with that being said, we are continuing with our series on self-representation in court. And so we want to enable you to continue learning about all of these important topics so that whether it's something that you are taking to court in terms of a civil case or you're responding because all of a sudden you're facing some sort of administrative or criminal charges, we want you to be able to handle that. Yes, and John on YouTube is reminding us all to smash that like button and, of course, share if you're on Facebook or the social media platforms that allow that, and subscribe, hit the notifications button as well. In a couple of years or so, when I get a little bit more free time, I may even get fancy and have that little click button that shows up in some YouTube videos so you see what buttons I'm talking about if you're new to YouTube yourself. At any rate, I am worried that this PowerPoint might look really crappy because, like I said, it's a new way of doing it. So it actually converted it out of a Google Slides format and into Microsoft. Sorry, I swore at you guys today. I know it's a little early in the day to start swearing like that. But anyway, I think that's why it does look bad on the screen here. But anyway, just hang in there with me. Hopefully the rest of it will be fine. And I won't use this method for the Constitution segment recap that we'll have on Thursday. All right, so we are continuing that series on self-representation. Again, today going over the 5 most common pre-trial motions, so before your trial. And that's, whether your case is civil or criminal, this information will help you to be best prepared for trial or to avoid having trial if that is your goal. So I'm going to throw on there a comment from the Liberty Cause. He agrees that most attorneys suck. There are a few who actually care about the Constitution. Dare I say, a few that actually can spell the word Constitution. And with that, we are moving on. Oh, no, this looks insane. Okay, guys, hang in there with me. Lori, does that look as crappy to you as it does to me?
Yes, it does.
Okay, we're leaving that.
Very disappointing.
I don't know if it's the streaming software or Microsoft, but I'll blame Microsoft. So, all right, I have the other one already. I will just go back in that. All right, here we go. Something that's going to work a little bit better. Oops. As I try to resize
here. I guess it does go bigger. Because if you needed to kick me out, I could interrupt you when our guest comes.
Okay.
To make it bigger.
Well, yeah, I get, we'll leave you in for now. We know how much you hate it, so we'll punish you. Bill Gates is the root of all things evil, says our friend. Yes, and I'm working on a Windows computer, so, I think I made it mad when I said that Microsoft was the cause of all the problems in doing the slideshow the other way. Anyway, all right, now I'm clicking in the wrong spot, though. See, look at that slide. It looks so much better, doesn't it? And definitely this one looks better. So this week, as always, on Tuesday, true or false question at 10 a.m. is posted. Again, we've narrowed down to just YouTube community and Telegram channels. That would be t.me/restorefreedom or youtube.com/restorefreedom, and you will get to our YouTube or Telegram channels. And so today's question, you can still go on there and answer anytime between now and 10 p.m. tonight when the answer is posted. Motions to dismiss or motions in limine, motions to compel, to quash a subpoena, and for a more definite statement, are common pretrial motions in both civil and criminal cases. True or false? So make sure to check that out and answer that question on Telegram or YouTube. All right, so we're going to start with the motion to dismiss. Then we're going to talk about the motion to suppress and a motion in limine. Talking about then a motion for discovery and the sister motion, a motion to compel discovery. A motion to quash a subpoena would be next. And kind of a sister motion or analogous motion is a motion for a protective order. And then a motion for a more definite statement. Again, this is not, if you're an attorney and you just want to learn more about motion practice or trial practice, by all means, you are more than welcome to join us today and even join in the discussion. But this is really meant to give you guys who are not attorneys the essential knowledge so that, let's put it this way. Let's say you are lucky enough that you never find yourself having to go to court for anything. Well, first of all, then I'm going to tell you you're not doing enough freedom activism if you've never gone into court. But let's say you are in that kind of scenario, you just make it all the way through life. You never have to go to court yourself. And you're thinking, well, gosh, I don't know when to use this, or would this even be necessary for me to know? Well, let's think of the most famous person probably at this point in the entire world. Anybody got any names? Lori, you got any suggestions? Who can you think of, a famous name that comes up to the top of your head that's in the news frequently?
Does it start with a T?
It sure does. It happens to be someone who also lives in the state of Florida now, Mr. Trump himself. And so President Trump is in the news a lot for what? Well, one of the things he's been in the news for a lot would be all the court cases. We started hearing about stuff with Rudy Giuliani in 2020. We started hearing from Sidney Powell in 2020. We had cases in all different states, state courts and federal courts. We have criminal cases now, cases in Florida, cases in New York, cases all over the country involving just the one guy. And let's face it, it's in the news. So you're like, oh, I guess I kind of want to at least know what's going on with that. How much better would it be for you to understand what's going on if they mention a certain kind of motion or even, oh gosh, Lori, who are the people that put out the 2000 Mules video, they were arrested, thrown in jail. Can't think of their
You're
name.
making me think too hard.
I'm sure some of you might know. Anyway, they found
Speak up,
themselves
guys.
illegally put in jail during the course of their case, and I believe it was a civil case in the first place. At any rate, they filed motions, and it was the successful motion practice that ended up getting them released. And so some of those very concepts are things that we're going to be talking about today. So again, even if you never end up in court yourself, this is information that will help you understand, as cases are talked about in the media and other freedom fighters are going through, various court cases, what's happening. Let's see. True the Vote. Yeah, that's the name of the organization. I just couldn't remember. I can't remember the blonde. There's a blonde lady. And then, anyway, maybe we'll have Dinesh D'Souza on as a special guest, and he can fill us in on the names. No, I'm just kidding. He's definitely not our special guest today. We have somebody way cooler than Dinesh D'Souza.
Yes.
All right. So the first one is motion to dismiss. Well, D'Souza, somebody on Facebook, David, thank you. D'Souza is the one that worked with her, but he wasn't jailed. He talked about her being thrown in jail, and I don't remember if it was her and her husband, or her and her partner with True the Vote. I can't even remember the details. I posted about it, but there's been a lot going on in the last several months, and so that's information my brain has decided not to retain. All right, so the first one is a motion to dismiss. Now, I'm going to tell you right off the bat. Well, first of all, what is it? It's pretty obvious, right? A motion for the court to throw out the case. Yes, thank you. Wow, and leave it to Mr. Catherine Henry. No, leave it to Mike Henry to give us the answer. Catherine Engelbright. It's probably why I didn't remember it, because she spells her first name wrong, and then the last name, I don't know how to spell that by themselves without having to copy and paste. Anyway, okay, so this is officially, the Black's Law Dictionary would describe a motion to dismiss as a request that the court dismiss the case because now there's been a settlement, or because the plaintiff wants to voluntarily withdraw. Excuse me. In Michigan court rules, you actually wouldn't do a voluntary dismissal under, it'd be a different court rule, which I didn't cite here, but I think that one's like 2.504 maybe for a voluntary dismissal. But at any rate, or the biggest one is there's a procedural defect and you want the case dismissed. Maybe you're the defendant in a criminal case. Maybe you're the defendant in a civil case. Regardless, maybe it's the city trying to bring illegal or unconstitutional action against you in a special magistrate hearing. You might start off with a motion to dismiss. All right, sometimes it's called a motion to dismiss. Sometimes, like in Michigan, it's called a motion for summary judgment. So just keep some of those terms in mind. So what are some of the reasons that you can file a motion to dismiss? Well, number one, the court lacks jurisdiction over the person or the property. The easiest example, let's say the state of California wants to exercise jurisdiction over me. So somebody that lives in California decided that they, I don't know, they don't like me, okay? And they don't like how I'm using my real estate, my house, for some reason. They don't like my fence. I mean, I actually have a neighbor like that here. But let's say she moves to California and she still doesn't like my fence. So she brings a case into California court and says, I want to bring her into court because I'm going to sue her over her fence. Well, California has no jurisdiction over me because I'm not there and my property isn't there. So the court has no jurisdiction, no personal jurisdiction over me. So next one, process issued in the action was insufficient. So that's the kind of case it is. So for example, I know this stuff can be totally boring and overwhelming, but think about it this way. Many of you know about my Allegan County election day case from 2020 when I was violently arrested by 3 deputies because I showed up to be the attorney for people who were circulating a petition lawfully at a polling precinct in Michigan, election day 2020. The officer actually wrote me a ticket. Initially, the ticket that was filed in court and everything was filed as a civil infraction for trespassing. Why would that be relevant here? Well, the process was insufficient. What does that mean? There is no civil infraction for trespassing. You can file a civil lawsuit as a plaintiff, over, somebody that's trespassing on your land, like say, oh, I don't know, Janet Bruce from the city of Ormond Beach, who thinks that she has the right to come onto private property. But anyway, otherwise it's a criminal case. But there's no middle ground. There's no civil infraction as a criminal trespass. So the process, the document itself was defective. It doesn't exist. Okay, then service of process. Well, I was never actually served with with any kind of complaint that was a criminal complaint. Can you imagine that? I went through almost 2 years of battling in Allegan County courts to get that case dismissed. And one of the things that I filed on initially was the fact that they never served me. They never served me with a criminal complaint ever. When they eventually added a second charge to the complaint and filed an amended complaint later on, a whole year later, they never served me with that either. I just happened to get a courtesy copy from the court, but the prosecution never served me, not once, with a criminal complaint. Isn't that crazy? Okay, so that is something that you can raise to get a motion to dismiss. Number 2, this is my favorite one, lack of subject matter jurisdiction. What is subject matter jurisdiction? Well, don't worry, I'm not going to put you to sleep talking about that today, but you can definitely have some good, peaceful listening if you check out the, 2 or 3 different full episodes that we've done throughout the last year and a half, specifically on subject matter jurisdiction. We've talked all about it. I have legal briefs on my website about it. In fact, you could type in subject matter jurisdiction right on our website, and you should be able to find some good stuff. Oh yeah, I guess it's tax day. Oh, Joe on Facebook is pointing out that it's government extortion day, and it had me thinking, what in the world? Okay. So I'm so sorry, guys. I noticed there's some discussion going on and I wasn't taking it all in.
Our special guest is with us too.
Ooh, okay. So let's see. I'm just making sure I didn't. Yes. Oh, Accurate Amanda. Awesome. So she's in the chat today. Let me do this. Lori, please jump in if I'm missing anything. I'm going to throw you backstage and bring in our special guest today. Where did he go? Okay, is it going to work on my end? There we go. I think it's working. Okay. Can you see and hear me, Foshin?
I can. Yeah, can you hear me?
Yes, I can hear you. Your video is choppy, but it'll work. The audio works, so. All right, and guys, I just have to comment. Check out his background. I mean, that is a pretty awesome background. I'm assuming you're at home now.
I am. Yeah. Back on the compound.
He has, just a tiny little property here in Florida. Good. Let's see, 80 times larger than mine. Anyway, so don't get lost on your own property. All right. So, so basically, and I don't know. So Accurate Amanda is here with us today. I'm not sure if, let's see if I'm going to get his name right. Palm Beach Free Press, maybe. If he's going to join us today, but in the chat anyway. But he is also someone that's experienced some of these very things and has to go to round 2. But I'm going to finish talking about this motion to dismiss, and then we're going to kind of pause on that and then interject some cool real life stuff from a case that actually saw some court action today, and all from freedom fighting. So let's see. Okay. I was checking out the chat, but let's see. Getting back. So real quick. So these again are the The reasons that you can file a motion to dismiss, these are common reasons. So after the subject matter jurisdiction, right, the court has just no jurisdiction over that kind of thing. Well, I guess I glossed over that a little bit too much. What does it mean? The court literally doesn't have jurisdiction over something. So for example, I don't know, let's say that there is a case where an attorney is arrested while representing somebody, and they're represented for a misdemeanor. In Michigan, there would be no subject matter jurisdiction because attorneys are public officers, and a public officer cannot be arrested for anything other than one of three exceptions, right? So treason and two other ones. So basically, the court wouldn't have jurisdiction, but the court would never, prosecution would never try to prosecute somebody for being an attorney. Obviously not. I know. Another really good example would be, let's say a special magistrate at a code enforcement hearing was trying to exercise jurisdiction over the property of a homeowner to the extent that they were going to allow the city to go onto the property, tear up the homeowner's property physically, remove it, and then charge the homeowner for that. That would be a clear example of a lack of subject matter jurisdiction. Not that anything that insane or stupid would ever happen in court, but that would be a good example. Okay, so next, a party asserting the claim lacks the legal capacity to sue. So you hear about standing, right? A lot of the 2020 cases were dismissed for one reason or another relating to standing. Oh, the court said that the party didn't have standing to challenge the election results here, or they didn't have the standing to challenge an executive order in this state or whatever. It's mostly garbage, but basically what it means is, let's say it's a contract, okay? It's over a contract, and you have some third party that is not, has nothing to do with the contract. If Foshin and I have a contract and Lori decides she wants to sue one of us about the contract, generally speaking, she doesn't have the capacity to sue about that because it's not her contract, right? So she doesn't have the legal capacity to sue. Another one, there's already an action going, right? Foshin and I have a contract. He wants to enforce the contract, and he's already filed some other kind of lawsuit about it. Now he's trying to file in a different county for the same case. He can't do that. And then release, payment, prior judgment, immunity, statute of limitations, infancy. So basically, this is if, let's say somebody sued Emma because they don't like our privacy fence. She could have the case dismissed against her because she's 9 years old. They can't sue her for any of her, property rights relating to this fence. Payment. If Foshin sued me for this fictitious contract we have, and he wanted me to follow through in this contract, if I was able to show, hey, I already followed through, I already paid, well, that would be a good reason to have the case dismissed, right? Or what if he waited too long? What if Foshin wanted to follow through on this contract that I violated, but I violated this contract 20 years ago? Almost every state would say, hey, 20 years is way too long to try to sue somebody for a broken contract. Sorry, case is going to be dismissed. All right, so last three reasons why you can file a motion to dismiss. This is one of the big ones, okay? That the opposing party has failed to state a claim upon which relief can be granted. I may have also used this in my Allegan County case, but basically, where the court or where the prosecution or the other side has a claim, they're asking the court to do something that there can be no relief on that. If you want some really clear examples that I can't come up with off the top of my head, check out my website where you'll see a bunch of briefs and how I use that and the other cases that I cite about that. Number 9 in the Michigan court rules anyway, is that the opposing party has failed to state to state a valid defense. Now, that's not applicable in a criminal case, because in a criminal case, if you are the defendant, you literally don't have to do anything other than show up. And even then, they can have a trial in your absence. Not that you'd want that. But you could sit there totally silent the entire time, and it's still the prosecution's burden of proving every element of the offense in order to prove that you're guilty. So they can't bring this up. They can't say, oh, well, you failed to state a valid defense. No, that's only in a civil case. All right, and then except as to the amount of damages, this would be in Michigan Court Rules 2.116C10. This is one of my favorites as well, that there is no genuine issue of material fact and that the moving party is entitled to judgment as a matter of law. So for the arrest case that I had in 2020, this was one of the things that I argued because I said all along, we did not disagree about the facts. There was no dispute. They never said I was incorrect about where I was parked, where the circulators were parked, where I was, what I said, what they said, all the facts were there. We agreed that the city clerk tried to tell me I wasn't allowed to be there. Yeah, she said it. She's a moron. She had no right to tell me that. So we disagreed about the law, not about the facts. And so anyway, that would be a motion to dismiss claims. So with the first three that we talked about, you have to file them right away, typically. Otherwise, they're waived. You can't bring it up again. So if the court doesn't have jurisdiction over you as a person, you have to bring that up right away. Otherwise, if you just keep going through the court case, then you can't bring that up later. They'll say, sorry, you basically accepted the fact that the court now has jurisdiction over you. The process was issued, meaning the kind of case, and the service of process, how or if you were even served at all, that you have to bring those issues up right away. Subject matter jurisdiction, the big one, can be raised at any time. You can even not realize that there's no subject matter jurisdiction at the trial level and just bring it up on an appeal for the first time. It's like the only thing you could bring up on appeal for the first time, but that's something you could bring up at any time. Numbers 5 through 7, they have to be raised at some point in your responsive pleading. So when you respond to whenever you file a responsive pleading, they have to be raised then. And then the last three that are those big ones we just talked about, they can be filed at any time unless the court has issued some sort of deadline for dispositive motions. Any motions that can dispose of or throw out the case, or complete the case before a trial. That if that time period has been set by a judge and it is now passed, then you can no longer file. And then I threw in there some of the, you have Michigan Court Rule 2.116, the Federal Rules of Civil Procedure 12B, Florida Rules 1.160 and 1.140, just as some rules to get you started with. But before we go any further with the motions, I want to talk about motions stuff. Wow, I'm almost a poet. So tell us, please, what was it? So you're all, I don't know if you guys can tell because I have the border around this here, but let me see if I can do something a little bit different here. It's not going to cooperate. I'm not sure what just happened there. I just lost my ability to change the, oh, I got to hide my, there we go. Oh, now I'm huge. Okay. So, all right. And it got rid of everybody. What just happened? Okay, there we go. Sorry, my computer's freaking out. All right, so now I've made us all big and you guys can see how much fancier Foshin is than I am. So Foshin, can you tell us, why are you dressed up today? What was going on in Orlando? Oh no, I can't hear you. Hold on a second. Oh, you're not muted on my end. I don't know if there's something on your end, but I can't hear you at all. I cannot hear you. I'm going to throw Lori in here. Hey, Lori, can you hear Foshin or is it just me?
No, I can't hear him.
Okay. We can't hear you at all, Foshin. We could. I was hearing the background sounds of where you are. Hopefully he's going to come
I think he'll probably, yeah.
Okay, so in the meantime,
refresh the connection.
Stairs Up Plants, which if I'm remembering correctly, is way up in Houghton Hancock area of Michigan. I'm just going to say nana nana boo boo. I have 70 and 80 degree weather. No, that's not nice. But thank you for joining us from Northern Michigan. What was the question? How does one complete service on a motion to dismiss? So each state is different as to how you serve a motion to dismiss. For example, in Florida, there's basically e-filing is the mandatory way of serving most documents. In Michigan, the court rules, there's a couple different ways that you can do it. But I believe, well, my case was pending during COVID, and so there were temporary orders that basically forced even courts that weren't doing e-service and e-filing stuff yet to implement that, at least in 2020 and 2021. And so I just served the prosecutor by email. But in your case, that you have a civil case, if I'm remembering the right person to the right screen name, you have a civil case, and so I would, you can physically have an adult 18 years or older serve them, or you can, you might be able to e-serve them as well. It just depends on a couple things. Foshin, can we hear you? Let me see.
Can you hear me?
Yes. Okay. All right, Lori, I'm going to put you in timeout again.
Good.
Okay. All right. So glad to have you back in here. Okay. So today is Tuesday, April 18th. And at 9 or 9:30 today, you were at a party, right?
Yeah, I was at a party. I was down at I think 400 West Central Avenue in Orlando at I think it's I'm not sure if it's district court or what, but I was at the courthouse there. I think it is district court.
Federal district court.
Yeah, to appear for my six citations, 3 for filming and 3 for disobeying signage and disobeying authorized, people advising me to stop filming. So I sat down with the prosecutor, and ironically, the Federal Protection Services agent that issued me the citations. She hadn't seen the case until I'm assuming she met with him. So she wasn't real familiar with the actual CFR that I was being charged with, and what she said is she wanted to see if we could find a resolution today, and if we couldn't find a resolution today, that we would put it out 30 days and revisit it then. And I asked her what resolution looked like to her, and she kind of she asked me about the charges, and that's kind of when I got into my position on the matter, which is that I was following the letter of the law, and I don't I don't think that the charges are just, and I'm certainly not going to plead guilty to charges that to something that I didn't do. So I think that she at the end of the conversation, she said that she needed to look more into the issue, more into the CFR, because just from my search, it doesn't look to be a federal regulation that is that's, I'm not sure what the word I'm looking for is, adjudicated. It's not a charge that they see often. So I don't think that she was familiar with the law, and I think she was probably buying herself some time to educate herself on the law. But it came down in the conversation, at least, to the fact that I was disobeying a security regulation, or I was disobeying a security directive, regardless of the fact that I was I was following the statute. I was filming in an area that it said I could film in, for the purposes that I said I was filming. So I don't know. We'll see. We'll see where this goes. But you go into a situation like this, and you want to have faith in the system, even though that there's little justice in the justice system, which is it's disconcerting for sure.
So just, I know I've talked about it a couple of times, but just for anybody who's new, although my streaming software is somehow saying that we have 0 viewers, which is ironic because we have people commenting. I don't know how they're commenting without being viewers of the stream, but at any rate, thanks to my software, yay. Okay, so anyway, what the case stems from is that you were at the Social Security Administration building, right?
That's right. So I visited Social Security in DeLand, Florida. That was where the original incident was, and I was trespassed from the building, and I was charged with 2 CFR violations: 41 CFR 102-74.385 and .420. 420 is in regard to filming, and .385 is disobeying instructions, from authorized personnel. So I got 2 citations from that visit, and then I visited the Social Security in Kissimmee, and I got another 2 at that location, and then I visited the Social Security location in Orlando, and I got another 2 at that location. Now, these weren't served to me at the time. These were all served to me at one time. I had an appointment with the chief of police in DeLand to have a conversation about the original trespass issued by his agency. And instead of sitting down with the chief that day, I was met by Federal Protective Services and issued these 6 citations. So that was pretty shady.
Oh, I just had a bell go off that so you said something about going to DeLand and there was like a bait and switch and that's what you showed up for. And with all that's going on my end, that never clicked for me that that's what you were talking about. So, wow, that is really shady.
Yeah, which is ironic, because, had anybody just called me and said, hey, we've got some citations for you, I would have happily come and picked them up. I mean, I'm not out here to break the law. I'm not out here to violate the law in any way. And if, obviously they think I have violated the law, but I mean, why do you have to do some shady shit like that? Just give me a call. I mean, these are things that could have been mailed to me.
Yeah.
So this just looks like a big flex on, let's show this guy what we think of him.
Yeah. Well, I mean, and to waste your time, because for you to drive to DeLand, I mean, that's, I don't know, is that 40 minutes? I have no idea.
Well, yeah, no, it's a little closer, but your point's still valid. I mean, I don't want to waste my time doing anything that, I mean, my time's valuable. So it was just shady that, they're going to set it up as some, yeah, sure, sit down with the chief, let's have a conversation, let's have a conversation about the law. And then it's just like, oh, joke's on you.
Yep. Yeah, that's total garbage. So, at any rate, at this point, to those of you who are, curious about Foshin's case, and by the way, I don't know if Lori has had a chance to do it yet, but if you're looking for information about him or the work that he does or why he was at the Social Security office in the first place, check out his YouTube channel. This is a public service. And you just have YouTube. You don't have like Facebook or anything like that for that, right?
Oh, no, I've got Facebook. It's just much, much smaller. And all of my content is on YouTube, where the stuff on Facebook is kind of lagging. And I set it up later, so I'm catching up with all that stuff. But
Okay.
Yeah, if you want to know what's going on, when it's going on, YouTube's the best spot to find me.
Okay. So, and let me tell you guys, Foshin is one of those guys that's a freedom fighter who's just in the corner of anybody who's on the side of justice. Because a week ago, Monday, when we thought that the city of Ormond Beach was literally going to start coming and digging out our pavers and our shipping containers and our privacy fence, because that's what they said they were going to do on April 10th, and I hadn't yet received an order in hand saying that the special magistrate orders were paused or stayed by the appellate judge. Foshin's one of the people that showed up like James Madison Audits and a couple of other Geo and a couple of other people showed up to literally have a car parked on my pavers and in front of my fence and just be present to fight the tyranny face to face. And so that was greatly appreciated. So that's the kind of person we're talking with right now. This is not someone who just goes somewhere just to stir up trouble. This is someone who just likes to expose the truth and to make sure justice is being had for anybody in any situation. So at any rate, he's also not an attorney. In fact, I don't know if I've ever asked you, what is your I can't even think of the words. What are you by trade?
Yeah, I'm an entrepreneur, so I'm a small business owner. We own a couple small businesses, and that's what I got going on.
Okay, well, I'll have to talk to you about that afterwards, because who knows, maybe you have a small kind of business that I'd like to utilize for whatever it offers. So anyway, so you are not an attorney by trade. You're not, in the legal profession. This isn't your paid gig, so to speak. This is your passion to fight for freedom that led to these charges. And so you are representing yourself, though, right?
That is true. Yeah.
And my understanding is that you, at least in part, kind of came to that conclusion to represent yourself based on the conversation that Acura Amanda and I had about, I think it was about her charges that have finally been dismissed, but that she received while she was out there doing First Amendment auditing types of work. And she made the famous comment about, hey, no one's going to advocate for yourself any better than you will. And so that whole discussion that we had kind of inspired you to fight for your own freedom and not rely on an attorney who might not have all the time or the resources or the passion to get it done right. Am I kind of on the right track?
This is also true. I was probably looking at, beginning at, $5,000 to $10,000 just to get somebody to represent me in that forum. And, I read law, I try to understand what I'm getting into before I get into it. So I'm already doing some of this legwork. I'm already reading case law. I'm already doing some of these things. So,
hey, don't ever say
you
that
guys said
again.
that.
There's no case law. Doesn't
Okay.
exist.
Precedent. Should I say that?
Yeah.
Case precedent.
Yes.
So when I heard Amanda say that it just kind of struck me, and I had to analyze that. I'm going to give this person the money, and then what? I'm just going to be hands off. Am I not going to be involved anymore? And, that was something that the prosecutor said today. Well, when you get an attorney, just give them that number that I gave you because we can't talk to you anymore. Well, what the fuck is that? I want to know what's going on. So, I think there's a saying that, only, something about having a fool for a client, but I think there's probably more to that quote that everybody's missing. So.
Yeah, I mean, yeah, I was told that myself, that, well, anybody who represents themselves has a fool for a client. I was told that many times, but I know damn well that there's literally not an attorney on the planet that I know of that was actually willing to read the motions that I had already filed, let alone, to know the whole facts and do all the background so they could jump in and take over the case for me. So if they're not even willing to read it, let alone write it, how could they possibly have fought for me any better than I fought for me? And I know damn well that it wasn't that my motions were done wrong or that my interlocutory appeals were done wrong, why it took so long to finally get it dismissed. No, I had shitty judges at the district court and circuit court and court of appeals that got assigned to my case who didn't give a shit about the Constitution. So, and I am an attorney, so it's a little bit, not the same in some senses, but it wasn't because I was representing myself. It wasn't that my stuff was denied, my requests were denied just because I was too, involved in it or whatever. And that's what some people say about representing yourself. It does become hard. If you're too ingrained, you're too close to a case. Sometimes when you're putting stuff together, you leave out some of the obvious things that are obvious to you that might not be so obvious to the judge or the jury or something. And so, yeah, you need, another pair of eyes, at least one, to help. Sorry, the Liberty Cause is saying that the judge assigned in my case was a moron. All of them, because not a single one of them cared about the Constitution or anything else for that reason. So, all right. It looks like we had somehow had a bad link for you on YouTube, but it looks like Lori fixed it and was able to share the correct link, or something was going weird with your YouTube channel, but she was able to share something that worked for people. So, Good Citizen on YouTube says, I've been following Foshin on YouTube on This Is a Public Service for a long time. He is a first-class act. Well, he's my friend.
Appreciate that.
Have him. Oh, wait, sorry. No. Yeah, we're truly blessed to have, have found friends like Foshin here. Like I said, This Is a Public Service is his YouTube handle. James Madison Audits, the Liberty Cause. I'm struggling to think of people's handles and not their real names, because some of our freedom fighting friends have a day job that they just like to keep the anonymity for that purpose. But Accurate Amanda and Palm Beach Free Press. I mean, good, really good freedom fighting, Constitution loving, God loving people that we're very blessed to have as friends and fellow freedom fighters down here. And of course, not that I'm not having love for my Michigan freedom fighters and people that are still up there working super hard, like Joe Moss leading the way. He's been in national news a few times now. He tells me he learned from the best. So I'd like to think that's not just patting me on the back, but he really means that. Rachel Atwood and a lot of other friends that are still fighting the good fight up there. So at any rate, I'm trying to figure out, let's see, what would be the best way? Basically, Foshin, for you, I would think at this point you might want to look into, and maybe you already did and you told me and I'm just totally spacing it, like I've done way too much recently with all the stress going on, but if I were you, I would file some of those motions to dismiss. You could do them all together in one. You can break them up separately if you really wanted to, if there's a procedural benefit to you. But there's some of those motions to dismiss that you might want to look into filing. Now, keep in mind, guys, for Foshin, it was a federal building. So he's being charged in federal district court. And so the federal rules of procedure apply. There's federal civil rules and federal criminal rules, and then the federal rules of evidence as well. So for his case, if he wanted to file a motion to dismiss or anything like that, he needs to be paying attention to the federal rules. Literally, you don't look at the state court rules at all when you're in federal court. So I actually sued our city manager and city council in personal and professional capacities back in 2015 for violating my rights. And so their overpriced attorney paid with my tax dollars, moved it to federal district court, where we were in front of a federal magistrate judge as well, like you were today. And that was a whole bunch of fun. So I do have motions that you could copy from, at least to some degree. I mean, that was a civil suit I brought against them, but there's still some good, some formatting and types of things that the federal rules would mostly apply. And keep in mind, guys, one more complication. Sometimes there's local amendments. So if you're in the Western District of Michigan Federal District Court, because there's two federal district courts in Michigan, Western and Eastern. I'm admitted to practice in both, but they each kind of have some local amendments to court rules at times. That can trip people up. So at any rate, just something to look in mind or keep in mind, look out for. But Foshin, what do you think? So I don't know if you probably weren't in yet and able to hear the 5 main motions that we were talking about today. We have a motion to dismiss, a motion to suppress, a motion for discovery, a motion to quash a subpoena or for a protective order, and a motion for a more definite statement. Now, I haven't even told everybody else what some of those really mean yet, so it's okay if that's just a bunch of legal lingo that doesn't make sense to you at this point. But does any one of those kind of motions jump out at you as something that you want to explore or discuss or whatever in terms of what you're going through?
Well, I think I'd probably have a question. So, I mean, to me, this just seems like a real clear cut. I was following the letter of the law. So, if somebody can still be charged for that and they still have to go through all these processes, just seems ridiculous. So, I would think that one would be able to file a motion to dismiss. But, I'm pretty green, so I'm not sure what you would say in something like that. Well, what exactly am I being charged with? Following the law, or what? So, who knows?
Yeah, so you might want to check out one of those, the different motions to dismiss. I haven't read the specific codes or the things that relate to you, so at some point, maybe you can have them printed off and we can just sit down over some lunch. I was going to say coffee. I don't drink coffee, but anyway, sit down over a root beer Zevia or something and talk about it. But we can brainstorm yeah, it might just be a lack of subject matter jurisdiction. It might be some sort of, that's probably the best one, quite frankly, or it might be a lack of jurisdiction over. No, I would say it probably would be because you were physically present, so it wouldn't be that there was no jurisdiction over the person. You were present at the federal building, because you would say yes to that. So I would say it's probably one of the issues of a lack of subject matter jurisdiction, or one of the latter three that we talked about, which would be a failure to state a claim upon which relief can be granted, or that there's no genuine and this one's probably a big one here. There's no genuine issue of material fact, but the law alone says that you should win, that your case should be dismissed or whatever, that you had a right to be there, etc. So those three, which are the three biggest ones that I used in my Allegan County case. So yeah, I would think you'd want to do something like that. And the reason why I wanted to talk about this, guys, during this and bring him on there is to give you guys a real life example and how you would think through how your case would apply to the court rules or vice versa. So you can think about, okay, what kind of motion could I file? When would I file it? And so, like I mentioned, with subject matter jurisdiction, you could bring that up at any time. But if I were Foshin, I would file it before the next hearing date. And then the other two that we mentioned, failure to state a claim and no genuine issue of material fact, those ones I would put in the same motion and file it before the 18th. Again, not that you would have to. You could file those right before trial, but those would definitely, there'd be some benefit to filing it before the next hearing date. And then yeah, I don't know what kind of discovery there might be depending on the whole situation. I'd have to see a lot more of, your videos on it and the documents that you have to see, but there might be information where you'd have to ask for specific discovery that it goes beyond what they might automatically give you. And maybe motion to suppress. Maybe they're going to try to introduce evidence that you disagree with. For example, for me, guys, in my now it wasn't a criminal case, but in my Ormond Beach, supposed ordinance violation case, the code inspector was here on the property and physically trespassing on my property and taking pictures, which violates the Fourth Amendment, among other things. And then tried to introduce those pictures as evidence against me. And so I objected, essentially. I actually made it more as a motion at the beginning of the hearing, but he denied my motion. But basically, I was saying that she had been on the property, and so to the extent she was going to try to introduce any pictures later on about that she had gotten while being on my property illegally, that I was asking the court to deny that and exclude those from evidence. Essentially, it's a motion to suppress. Now, a motion to suppress is technically only available in a criminal case. Hey, Foshin, is it actually a criminal case, or is it more of a civil infraction? What is
Yeah,
yours?
so the way they actually described it today is that, these are infractions, but she said that if we get past the next the next court date or whatever, and I still choose to, assert my rights, she said it's going to become a misdemeanor, punishable by, I think, 180 days in jail and a $5,000 fine.
Wait, back up. You said right now it's a civil infraction, but what turns it into a misdemeanor?
Moving forward is the way that I understand. I couldn't obviously record it because they don't like recording there, but
Right.
yeah, they made it sound like it wasn't a misdemeanor yet.
That is very strange. So basically, I wonder if is that the prosecutor that was telling you that?
Yes.
So maybe what they were saying is at this stage that if you essentially like took a plea deal, it would be for a civil infraction, but that if you go to trial, they're actually pursuing criminal charges against you.
Yes. Yeah.
Okay.
You said it better than I did.
So if that's the case, it's a criminal situation. So you could file a motion to suppress. The reason why I ask is because number two, guys, motion to suppress or a motion in limine, two different things. A motion to suppress is a request that the court prohibit the introduction of illegally obtained evidence at a criminal trial. So that is something, first you have to determine if you have a criminal or civil trial. So that is something that Phocion would be having, would be a criminal trial in the future if it doesn't get resolved. And so he may very well want to move to suppress evidence if he feels any evidence that they have was obtained illegally. Do you think, I guess I don't know what evidence that they might have, but do you think there's any evidence that they obtained illegally?
Yeah, I mean, the videos they're on YouTube. They're posted on YouTube. So I'm not disputing that I was there filming. There's no, yeah, I mean, those are the facts. And, as far as I'm concerned, it follows the letter of the law.
Okay. So yeah, probably it's not something that is relevant in every situation, but sometimes. I didn't file a motion to suppress any evidence in my Allegan County case, which was an actual criminal case, because we agreed just there too. We agreed on the facts. I put a map in my initial motion to dismiss, showing where I was in relation to where the front door of the polling precinct was, because the only law that really applied was that I couldn't be within 100 feet of the. In Michigan, it's 100 feet. Florida, it's 150. But I couldn't be within 100 feet of the door of a polling precinct on election day. I was 229 feet away, so I was way beyond what was required there. But at any rate, we all agreed on those kinds of things. So anyway, it's just something you guys need to think about. Sometimes people know just enough to be dangerous and not enough to really be good with the information. And so a motion to suppress is sometimes helpful, but also keep in mind it's generally not something that's used in a civil case either. A motion in limine, though, is something that came up with Palm Beach Free Press's case. I think it was last week. I think it was last Tuesday. And it was their motion was filed on Monday by the prosecutor. I don't know, Phocion, did you know about this? Have you and I talked about it, or do you know of Acura Amanda and Palm Beach Free Press, right?
I do know what's going on, but we talked about it on Monday when we were at the house, but I don't know what's going on. Neither one of I don't talk to Amanda outside of commenting on her Facebook, where we've never met.
Oh, okay. Well, we'll have to have a get together soon. But anyway, so they literally served him by email the day before trial, and that his was for a criminal case. Again, First Amendment advocacy, all of this stuff. What I was doing up in Allegan County, Michigan on Election Day 2020, what Phocion was doing here in the state of Florida, what Acura Amanda was doing in the state of Florida, what Palm Beach Free Press was doing here in the state of Florida, all First Amendment advocacy. No actual crimes were committed by any of us. But at any rate, so in his case, they filed a motion in limine and served it on him the day before his trial. They couldn't get their shit together any faster than that. And then I want to say it was something like 30 different paragraphs. They wanted to exclude, maybe it was more, but it was insane. But roughly 30 different things that they wanted to prohibit him from doing. Now, what's the difference between a motion to suppress and a motion in limine? And this is something, Foshin, that you might want to know too, because who knows what games the prosecutors are going to play in your case. But what a motion in limine is, it's a pre-trial, so before the trial, or apparently with them the day before trial request, that certain inadmissible evidence cannot even be referred to or even offered at trial. So they're saying you can't even bring it up during the trial to try to introduce it as evidence. And typically, Black's Law Dictionary explains, typically the party makes the motion when it believes that, in fact, I forgot. I didn't have my slideshow, so give me a second here, guys. Sorry about that. Okay. So typically the party makes the motion when it believes that the mere mention of evidence during trial would be highly prejudicial. If such evidence is mentioned, the judge may order a mistrial. Okay, so here's the thing. In their case, what they were asking in Palm Beach Free Press, in his case, what they were saying is he can't talk about his character. He can't talk about. They were asking the judge to grant this motion in limine, saying he can't introduce evidence about any prior wrongdoing from the police department or any investigations, IA investigations that are going on about these kind of arrests or their abuse of power. He can't introduce evidence about his character or, basically the fact that he thought he had the legal authority to be there and do what he was doing. They literally wanted to exclude him from really presenting any kind of defense whatsoever. And actually, I guess that did happen in my case, although it was just a verbal motion made and no follow through in writing. But in July of 2021, we had a hearing by Zoom in my criminal case where the prosecution was literally saying they wanted me prohibited from bringing up any legal defense whatsoever, even though for a case of trespassing, they have to prove that I didn't have the authority to do it. And if I thought I had the legal authority to be on the property, then legally, they cannot charge me with a criminal trespassing. That's the same in any state, but certainly in Michigan. And so, it's a part of the defense. And the judge agreed with them and granted their motion at that time. That was a whole year before we actually ended up getting to our final trial date. But they did it, 4 days before the trial date we were set for in July of 2021, where they were trying to stop me from introducing any evidence at trial at all or mentioning anything in front of the jury that talked about any of the Constitution or the laws that allowed me to physically be present on government property at a township hall on election day, outside in the parking lot. And so that's just insane. And what they were doing to him was insane. So
this is what they're doing to Rogue Nation. I had breakfast with him this morning. He has a court case up in Georgia next Monday. He has his trial, and I'm assuming they filed that motion that you're discussing because he can't mention the First Amendment. He can't mention the freedom of press, and I mean that's the foundation of the activism. That's the purpose of him being there.
Yeah.
It's just for a person that doesn't have a legal background, you look at this stuff and you say, well, I mean, these people don't have common sense. What the hell is going on?
Exactly. Is he representing himself?
No, he's got an attorney up there, but he's facing 1 to 5 years, for filming on public property. He was outside.
And please tell me that his attorney has fought, actually officially on the record, fought for his right to be able to introduce the testimony and evidence about the First Amendment and freedom of the press and all that.
I don't know the answer to that. I would certainly hope so. I'll refer him to minute 104 of this and see if he's got any insight. But he has, obviously this is nerve-wracking, right? But he and his attorney seem to be optimistic about things now. I mean, optimistic's a hell of a thing, right?
Yeah. Well, definitely, he needs to be careful. I mean, I'm not saying I don't know anything about his attorney, so I don't know if it's a good attorney, bad attorney, or otherwise. But he needs to make sure that a proper record is laid, because I'm going to point out here, even an motion in limine. Let's say it's they're trying to stop him from introducing evidence. Okay, so it's basically the state's motion in limine against him. But let's say, even if it was the other way around, it was his motion that there was some sort of inadmissible evidence that was being offered. What Black's Law Dictionary wants you guys all to know is that even if you have a judge that ordered, yep, okay, so the other side can't introduce this evidence at trial, they can't even bring it up. If the person does introduce it, the prosecution or whatever does introduce or even talks about that evidence that they weren't supposed to, then the party, he would still need to object on the record during the trial to make sure he's preserving that issue for appeal. He can't just rely on something that was already supposedly handled pre-trial. So it's all about CYA. Those better be your 3 new middle initials, your new middle name. If you are representing yourself in any way, it's cover your ass. I mean, and quite frankly, even if you're not in court and if you never make it to court, really covering your butt in these situations, in any situation. I mean, I just bought a new used car and it was all CYA in how they are handling things. I mean, I don't even want. One of the dumbass things they did is they brought my car down here. They drove it down from Jacksonville without a freaking license plate on it. They stole my license plate. It's at the dealer up in Jacksonville. So anyway, it's all CYA. But anyway, those are 2 different things. Same kind of concept: motion to suppress, motion in limine. A motion in limine can be filed by either party, and you can file it in a criminal case or a civil case. And we had some comments that were on the screen earlier that Lori was putting up, and I didn't mean to ignore those, but my contacts are really freaking out right now. They're super blurry. I don't know if it's my allergies or what's going on, but I can't read crap. I'm barely able to read my slideshow, which is, the lettering is ridiculously large, but I certainly can't read the comments, and it's way too tiny. So I'm sorry about that. If there's something I needed to address that I haven't yet, then maybe Lori or even Foshin will yell at me to do that. Something you might want to do, Foshin, so I'm going to talk about this really quick. A motion for discovery or a motion to compel. Now, a motion for discovery, that's an obvious one. You're asking the court to order the other side to give you evidence, right? To give you discovery, to answer questions. There's different kinds of things that discovery could be. It could be interrogatories. That's where you have a written list of questions that the other side has to provide written answers back. It could be a deposition where, let's say Foshin wanted to depose the I can't even think of the federal. Anyway, let's say in my case, if I wanted to depose the code enforcement officer who showed up to my property that day and ask her questions, it's on the record. It's not at a hearing, it's at a deposition, but there's a court reporter, there's a transcript. And so those are things, that's a tool that could be used. It could be getting actual physical, tangible evidence, pictures, police reports, video recordings, voice recordings, 911 calls, anything like that, any kind of documentation, dash cams, all of that. And if any of you listening right now is in a situation where you're representing yourselves and you need to file a motion for discovery, you guys can check out my website and type in the word discovery, and you should be able to pull up the motions that I filed, my request for discovery in Michigan. There's a new court rule that makes it a little bit easier on misdemeanor defendants to request discovery. So you still have to request it in those cases, but if the prosecution doesn't comply, then you can file a motion to compel. So like I just mentioned there, in a motion for discovery may not be needed if certain court rules or your state law requires the other side to automatically disclose certain information. But you almost always don't want to rely on that. You want to ask for any additional information that might be needed. And if the other side is not producing the evidence or answering your questions as you think they're supposed to, file a motion to compel that discovery. That can be used in civil cases, criminal cases, wherever the opposing party has failed to provide either required or requested discovery. I did put in the court rules. And again, as always, the Constitution segment recap, you'll be able to see these slides and be able to see the court rules later. But Michigan Court Rules 6.201 and 2.313 would be the criminal and civil versions. The Florida Court Rule 1.280 has some information on that as well, but just some examples. So yeah, and so with you in your case, Foshin, I guess I'm just trying to think. I don't think any of that would be relevant to you. I mean, I would still request. I would do a blanket form letter type of request for discovery to make sure you know anything and everything that they have. You know, so you're getting copies of their police reports. You're getting copies of any of their security cam footage or whatever. You know, statements or whatever their evidence is that they have, even if they don't plan to introduce it at trial. If I were you, I would want to request that right away. So yeah, I guess I would do that. And if no matter what case you have, I would request discovery. So even in yours, I would do that. I'm giving you lots of homework today. You're like, crap, I thought I was just going to talk about the fun I was having earlier. Now she's giving me homework. But I would definitely do that the more I think about it. So a motion to dismiss based on a variety of things, and a motion for discovery would be helpful. Now, two last items here. A motion to quash a subpoena. Most of you could probably figure out what this is. That's literally, you're asking the court to stop or undo a subpoena. So in my case, for example, last summer, to prepare for my trial, I subpoenaed several witnesses for my criminal trial. One of them was the prosecutor herself, the chief elected prosecutor in Allegan County. Another one was Allegan County elected sheriff himself. Why? Because the prosecutor was referenced by the deputies before they arrested me that she had been involved with the situation and had given them permission to arrest me illegally. And the sheriff was involved. And not only was the sheriff of Berry County that I was on the phone with at the time that the situation started. So I was on the phone with the sheriff of Berry County. He ended up calling the sheriff of Allegan County at this, while this is all going on. Not only did that happen, but when I was in handcuffs, already bleeding and bloody and bruised and beat up, the deputy decided to offer for me to talk directly to the sheriff if I wanted to. And so I took him up on it, and then he was all ticked off that I did that. So I don't know what it was about that, but apparently the sheriff decided he wanted to smooth things over. I'm not sure. I don't know how charging me then and having the case drag on for 2 years is smoothing things over. But so the deputy calls him up on his cell phone and has me talk to the sheriff while I'm still in handcuffs over speakerphone. And so, yeah, he was directly involved. I was going to subpoena his ass every single time we had trial. So I did. Anyway, the last minute, the prosecution decided that they wanted to try to quash. They filed a motion to quash those two subpoenas. And they claimed all kinds of garbage and all that. And those motions are on my website too, in the Allegan County case portion of the website. But anyway, it was a bunch of BS. And of course, I filed a response to that. But you can see an example of what a motion and a response to one of those motions looks like. So the other side of that, though, a motion for a protective order. There's a case that, Foshin, I don't know if you're investigating this one too or not, or if it's just James Madison Audits, but there's a case of where two cops in, I think it's Daytona Beach Shores, very close to here anyway, put their 3-year-old child, their own child, in handcuffs in a jail cell. And he's trying to do some First Amendment due diligence and investigate what's going on and share the information with the public about this case. And they went and got a judge. Actually, I think it's the same judge that I have assigned to my case for Ormond Beach, believe it or not. But they got a judge to sign a protective order so that no one, the public, cannot have access to any of the records, I guess, in the case, which is very strange. So anyway, that's one example of how a protective order might be obtained or what it's used for. But anyway, it's a request for the court to protect a party from potentially abusive action by the other side. Now, one example is like if you have trade secrets and, you know, it's a contract case or something. You don't want the other side to be able to use those trade secrets and throw all your secret information that you've worked so hard for in the public purview, or to benefit themselves from that information. But I asked for a protective order in my case when I sued the city manager in her personal and professional capacities in 2015, because they were asking for my medical records, my personal medical records. And so I was objecting to even having to produce that. And if I did have to produce it, I was asking the court to issue a protective order that they couldn't share that information anywhere or use it basically for any purpose whatsoever. So those are examples of a protective order. I don't think that's going to be relevant in your case, Foshin, but it is something that's out there. And your picture on my end froze, and it's a very interesting pose that you froze on, but hopefully it'll come back. I think I can hear you, but
I'm still here.
Okay, good. I can hear you, but you're just visually, you're stuck in okay, there you are. That's normal. And the last motion, this again, civil or criminal, a motion for a more definite statement. So what could this be? This is actually something that Foshin might want to employ himself. And who knows, Rogue Nation might benefit from this. I think potentially Palm Beach Free Press could benefit from this. So Mr. Liberty Cause, if I'm not sure if Accurate Amanda is still on or not, but if you or Lori could reach out to her or directly to Palm Beach Free Press, tell him to check into filing a motion for a more definite statement before his next trial. But anyway, for you, Foshin, it would be, I think, very relevant too. And what it is it's a request that the court require the other side to amend a vague or ambiguous pleading to which you cannot be reasonably required to respond. So in other words, there's some sort, let's say there's a complaint filed, you know, criminal or civil complaint filed against you, and something about it is just so vague. You're like, what the heck am I actually being charged with? What exactly is it that I'm charged with doing? It's a motion for a more definite statement. That, I think, and I did look at Palm Beach Free Press's, I want to say it's a 4-page complaint-ish. It's weird how they did it. But I think he would benefit from filing one of those motions. And for you, Foshin, I haven't seen the actual documents yet, but you might benefit from that, because maybe it would force the prosecutor to go through the motions of identifying exactly what it is and then essentially what the elements are that they would have to prove. And maybe if you get lucky enough, they would then realize, oh, yeah, I guess this isn't something that we can charge him with. Or we have to, you know, get rid of one of the 2 kinds of charges you have, or something like that. There could be some benefit to that, aside from just getting a better understanding of what it is that they're coming after you for. Not that you can't read the federal regulations, but it just might help narrow things down or clarify it in terms of what do they have to prove to the court or to the jury in order for you to be found guilty. What exactly are they asking for?
Yeah, clarity is certainly lacking coming from that side. So, I mean, if there's a more clarifying way that I need to understand this, well, you know, tell me. You know, I can't even remember or tell you how many times I've said something to that effect to every person, you know, along this process, whether it be the FPS agent or any one of the land officers or any one of the Orlando SSA people, and the Social Security person that showed up at the Land Police Department. You know, she didn't want to hear it. You know, I asked her if she wanted to have a conversation about these GSA rules that are on the wall, and she wasn't interested.
Wait a minute. A government official that's supposedly trying to have the law enforced didn't even want to talk about what the letter of the law said. No, that doesn't happen. Oh, wait. I've got video of me saying that as well, too. Yeah, I might. As long as you give me 5 minutes to talk about what the law actually says. Nope, we'll violently arrest you instead and threaten to take your kid. Jeez. I guess you're smart enough not to have your little people traveling along with you when you're, but when it was during COVID and everything was shut down and I homeschool, like what, there's not a lot of choice there. So I'm going to update this, guys, but there's going to be a slide in here that you guys will see on Thursday in the Constitution segment recap that just has the links for, I'll have the resources page totally, like the court documents page on my website, which is under resources. But I'll also give you the specific link to the Ormond Beach case and then to the Allegan County case, where those two are where most of the documents are. But like I've been mentioning, that case against the city manager of the city of Belding back in 2015 or so, that was against Meg Mullendor. A lot of the documents are KHVMM. Anyway, those are some of those documents are on there as well, and I'll continue putting more and more documents in my free time. But it's all meant to be. It's all been in the public purview at some point. I shared it on my Facebook page, or I shared it somewhere online at some point. And if you guys are interested in helping my continued fight, I did. Oh shoot, yeah, I got to pay the transcriptionist today because she got it done yesterday, or I think it was late Sunday night. She let me know that the transcript was done, and so I got to fork out, some thousands of dollars to pay her for that. So if you guys want to help me in my case with that, please check out that Give Send Go link. It's GiveSendGo/Save Henry Home, or you can go to my website, restorefreedomkh.com, to support us that way. You can also just donate to the general freedom fighting work that we're doing by going to restorefreedomkh.com/donate. Otherwise, Ocean, do you have I guess I've never talked with you about some of these things. I don't know if you're independently wealthy or if you have any kind of Give, Send, Go or donation link set up so that if people wanted to support you.
I do. Well, no, I'm not independently wealthy, and I've got some links on my YouTube page, but okay. One's a PayPal link and one's I think a Cash App link, but
okay,
yeah,
so
that's
you guys have
I'd be more interested in liking, sharing, or subscribing to my content to get it out in front of more people. That I think that would be much more valuable to me.
Okay. Well, and that's, really with everything, I would encourage each of you that are watching now or catching this later on I can't even talk today, podcasting software or whatever device, that you hit that like button, hit the subscribe button, notification buttons to everything that This Is a Public Service is doing on YouTube and Facebook, to our channels and what we're doing on YouTube, Facebook, Telegram, Twitter, LinkedIn, Instagram, Pinterest. If it's out there, we've got it. So, please like, share, subscribe, all that fun stuff, and donate when and where you're able to. If you only have $5, that's all that you could donate in that moment. Please consider donating the $5, because we are also not independently wealthy. In fact, I've gotten no money in other than donations for the last 3 years, because I've only done freedom fighting work for the last 3 years. So, and before I forget, if you guys want more information, like Foshin said, check out his YouTube channel. He's got a lot of information, not just the links for his PayPal and Cash App, but other videos and information that he puts out there. And he's starting to get more and more on his Facebook page. Do you have a website as well?
I do, but it's not live.
Oh, okay.
It's thisisapublicservice.com.
Oh, okay. So at some point, check out thisisapublicservice.com. And otherwise, check out our Wednesday Way to Get Involved challenge that we will share with you tomorrow on our website and social media. Our Constitution segment, 10-minute or less video. I've recently been told that TikTok now is no longer limited to 10 minutes for video uploads, and some of the other platforms are a little bit longer as well. So we may even go up to 15 minutes, but probably not on this topic. At any rate, so those Constitution segment recap videos have the link for the slideshow, and then I go through the slideshow in the video as well. So you have kind of double whammy access to that. On Thursday, we have freedom fighting tools that we will share with you on Friday. And, there are always tools that are helpful, at least 3 tools that we want to share with you that will help you along in your own freedom fight. So make sure to check those out. Foshin, is there anything that you think people need to know that we didn't talk about today, or any follow-up questions, I guess, about any of these kinds of motions or things that I can answer for you that other people might benefit from as well?
Can motions that have been denied be used in your appeals?
Oh, yes. So in case you guys didn't catch that, the question was, can motions that were denied be used in a later appeal? Yes. So for example, in my Allegan County case in I think by the time they actually let me file it, because they denied me filing my motion to dismiss, if you could believe that, I was actually able to finally file it in January of 2021, filed that motion to dismiss. February 4th, we had the hearing, and the judge denied it. I want to say it's a 4-page order. It was very, with like double spaced, whatever. It's very short, but basically he said I didn't have a right to file a motion to dismiss, that you can only do that in civil cases. That's what he said. That in a criminal case, especially misdemeanors, you don't have a right to file a motion to dismiss. Dumbass. Yeah. And so that was the basis that he denied. He didn't talk about any of the law that I brought up. He didn't say I was wrong about that. He literally said I didn't have a right to file the motion. So 2 things with that. I ended up filing a series of interlocutory appeals, meaning appeals before the criminal trial ever even happened. And I brought up that very thing, that he denied my ability to file the motion, and then basically re-argued the motion in front of the appellate court. But number 2, I ended up filing, let's say 6 different motions in, I want to say it was May of last year, because remember, my case wasn't even dismissed until just last July 7th. So I want to say it was May of last year. I filed, say, roughly 6 different motions. One motion by itself was for declaratory relief, where I'm asking the court to simply declare that it's true, that I have the right to file a motion to dismiss. I filed that as its own motion. And then I filed a motion to dismiss based on lack of subject matter jurisdiction. I file a motion to dismiss based on some procedural defects, like the fact that we had then been set for 8 trial dates, and so they were denying my right to speedy trial. And so there's several things. So I filed several different motions to dismiss. So I even filed, in my criminal case, I filed the same topics of motion to dismiss more than once. And the prosecution tried to get me stopped right then and there and say, we already talked about this. And I said, yeah, actually the judge didn't even rule on the motion other than to say I don't have the right to bring up the motion. Interesting thing is, we ended up having a motion hearing on that in person on July 7th, 2021, or 2022. And the judge never ruled on my motion, declaring that I do in fact have the right to file a motion to dismiss. He jumped over that, instead started hearing my motion to dismiss itself. So I thought that was funny, that he was basically trying to skirt the fact that he got it wrong before. But anyway, I just see 2A-EDU. Thank you so much for the $5 donation on YouTube and for the statement to keep up the good work. We appreciate all the work that you do. If you guys don't know anything about 2A-EDU on YouTube, check his channel out. He is awesome on YouTube. He talks about stuff in Michigan, but also happening all across the country. In fact, I want to say it might have been, I don't know, it was some other Western state that he recently was doing some sort of poster video about recently that it was good to know about. And if you plan on ever traveling anywhere, you really need to know what the firearms laws and regulations are from state to state, because even though they all violate the Second Amendment of the U.S. Constitution and typically your state constitution as well, you still need to know what's coming if law enforcement tries to pull you over or arrest you or whatever in some other state, because it'll be even harder to fight it if it's not even your own state. So, okay. So I am not sure if there's anything else. Did you have any other questions, or did I get them all for you, Foshin?
That was actually one of the comments. So.
Oh, was it? Okay.
Yeah.
Wow. Fine then.
I'm sure I'm going to have questions, Catherine. I'm positive about it. I just don't have them right now. All
right. So, and we will give you guys updates on some procedural things. For example, we've decided we might look into whether an attorney can be admitted to practice in federal district court in Florida without being first licensed in the Florida State Bar Association. So if we find that out, then things may be rolling in that direction at some point. Otherwise, Foshin's legal team is going to be full of some really smart, capable, educated citizens who love the Constitution, who might not necessarily be Florida licensed attorneys. So,
and I'm very fortunate for it. So thank you very much.
And we're talking about this is the Liberty Cause and all the smart things that he has to. No, I'm just kidding. Yeah, I'm sure he'll be part of the team too. But anyway, anyway, it's fun, even though it's stressful that we're all going through. Oh, my contact is jumping around in my eye. No, that's awesome. Anyway, have you ever heard of that commercial? It's some sort of, I don't know if, I think it's a LASIK commercial. And the lady's like, oh, I love it when my contact starts rolling around in my eye. It's like a gross game of hide and seek. Have you ever heard that commercial?
No.
Oh, it's so funny. And my husband thinks and I'm like, no, that's what it feels like. I've had a contact literally like rolling around in my eye for weeks before and come out in pieces. And I did nothing. It's not like I was rubbing my eye. It just decided to rip apart in my eye. So anyway, so fun that happened to me at the end as we're wrapping up this episode. But all right. So I have no idea what we were talking about, but thank you all for your support and joining us today. And check out all the information that Foshin has for you, that I have for you, and anything that we have on our website as well. So we look forward to seeing all of you on throughout our week's segments that we have, and certainly next Tuesday. Oh, one last question that I have for you, Foshin, is, oh shoot, I can't live stream it. What is your hearing set for next month? Is it just set as a pretrial, or what is it set for?
They actually didn't tell me that. They told me that I'd get notice in the mail. They just gave me the date and the time.
Okay, so let's follow up on that, because what I'm thinking is maybe what we'll do, that day is another Tuesday. I hate that they do these trials on Tuesdays, because then I can't make it to anybody's crap. But anyway, that should probably just, if it's just continuing the hearing out, then it might just be another pre-trial conference or something like that. In that case, it's not likely, I don't think, that you'd have to be there, past noon. But why don't we take a look at that? Because maybe what we do, if I can have the opportunity to meet you in New Smyrna and drive over to Orlando with you, go to the hearing, then maybe we could do like a debriefing with people at noon. So we get some, unfortunately, we won't have any live coverage or, video recording of things ourselves. But anyway, just to talk.
Well, we can file a motion, right?
Well, yeah, I mean, yeah, you can always file a motion. So maybe we file a motion. Hey, we should get the Liberty Cause to come as press and cover it from that angle for us. So then I can focus on the legal side of things, and we can work as a team and figure out how to not only help you, but then use that case or that hearing to educate other people that might be going through similar stuff. So
I love it when a plan comes together.
All right. Sounds awesome. Well, thank you for joining me today. And
thank you, Catherine, sincerely.
Yeah, anytime. And I look forward to being in person for helping and supporting you in May with that. And guys, I don't know if I told you, Foshin, or if I told any of you, but I actually have a hearing on my pavers case. We have an in-person hearing. Get this, I get a whole 15 minutes of a hearing. Not even do I get 15 minutes. My whole hearing is going to last supposedly only 15 minutes. So maybe that gives me 5 and the prosecutor, the city 5 and the judge 5 minutes to talk. I don't know. At any rate, in-person hearing, they did make accommodations, my reasonable request for accommodations to be in person and not by Zoom. And that, I think, is May 12th. I want to say it's a Thursday or Friday, but it'll be in Daytona at the Circuit Courthouse in Daytona. And I'll get information shortly about that. But and of course we'll have to pay to have the court reporter there and all that, you know, transcribing and stuff. So guys, please consider donating if you haven't, or donating more if you're able to. But anyway, so to Foshin and the Liberty Cause and everybody else out there, in case you want to show up to this hearing to see what it's all going to be about, see some magic happen, it won't take very much of your time, I don't think, if it's only set for a 15-minute hearing. But May 12th, I'll be posting the time and everything later, and it'll also be on our advocacy calendar that you can check out on our website as well. So, all right. Well, thanks everyone. I hope you all have a wonderful day.